Lots of my colleagues talk about the health sector, which is most important to them. But decisions are being made today as to the future of my constituents. I think we're one of the first ones which is going to be hit by these cuts. By Easter, it sounds like there'll be no hospital in Hemel Hempstead, which is a disgrace.
Hemmings.
Speaker, being as it's Department for Education and Science, obviously that, well, it's education and education skills, sorry. Well, it's education. All right, fair enough. I'm slightly out of date on that basis. But although I'm not going to cover areas of health and education that other people have covered, instead I'm going to cover some other aspects of health and education. Actually, there have been some novel issues today. There are a number of sensitive areas that deal with the relationship between the authorities and individuals. I must start by making a declaration of interest of sorts. I chair an umbrella coordinating group called dealing with reform in public family law called Justice for Families. I have no financial interest or declarable interest in terms of register of interests, but I am concerned about children and families. The government's green paper on looked after children demonstrates the difficulty for children taken into care. This was reinforced by the recent NCC report that showed that children in foster care are moved too frequently. A recently born baby that I've heard of has been with 5 carers in his first 12 weeks of life, for instance. In essence, what these reports show is that for children on average, being taken into care is not a positive step. We therefore have to be certain that this was the right thing to do. One of the difficulties in obtaining information about the child protection system is the secrecy of social services. It is claimed that this secrecy is here to protect the child. However, it seems quite clear that the secrecy is maintained mainly to protect any professionals involved from allegations of misconduct. It's clear, however, that the intentions of the majority of people working in this area are good, and there are many hard-working people involved who care very much about their clients. There are a much smaller number who cause large numbers of problems. However, the system as a whole is at fault, and to the extent that the Queen's speech doesn't deal with these issues, it needs to be considered by ministers as to what should be done. The system's fault was demonstrated by the current GMC hearing about David Soldall, where the GMC has been trying to keep things secret against the express will of the parents. I have, however, published at the request the names of 4 of the families, who are Janet and Lawrence Alexander, Sharon and Hannah Bozier, Janet Davies, and Davina and Ben McLean. The case of 15-year-old Heidi Frost in Essex is a good example where the secrecy of the family courts protects social services, but not the child. She's not allowed to answer her friends' questions as to what happened. In this case, social workers and paediatricians were shown to be in the wrong, but she's not allowed to tell people. As a result of this, she does not have a doctor, and she believes her experiences would be useful for any other children who were falsely accused. This actually works against the interest of the children concerned, who remains a victim of the system. There is an element of hypocrisy as far as adoption is concerned, however, with local authorities, because they actively advertise children for adoption and the details about those children, whilst their birth family are not allowed to talk about things. It's good that the government are reviewing the issue of secrecy in the family courts. The recent cases of Clayton v Clayton and the judgment of Justice Mumby in respect of Nicola and Mark Webster have opened up more than a chink in the armour surrounding the family courts. It may be that people like Heidi can now speak out, but the law is not clear, and checking it costs tens of thousands of pounds. There is no question that professionals have avoided scrutiny through secrecy and continually made errors that would have been picked up had matters been considered in public. It is very clear that too many children are taken into care. There is a number of reasons for this. There is the simple failure of the system where the system gets the facts wrong. The case of the Williams family in Newport, which is in the news recently, where a locum paediatrician diagnosed chronic sexual abuse and split up a family for over 2 years, when actually a more properly handled diagnosis at a later stage found no signs of sexual abuse. What was reported in that case was that the international evidence is that the UK took a wrong turn after the Cleveland inquiry and has been overtaken by other Western nations, and that there is a view that there is a tendency in the UK for paediatricians to overdiagnose sexual abuse. Another worrying case is that of the Webster family in Norfolk. Here, a radiologist has diagnosed child abuse based upon metaphyseal fractures, and children were taken off the family. Metaphyseal fractures sound very worrying to a layperson, but they're not the same as a broken limb. Indeed, metaphyseal fractures can be caused by being born and various bone diseases. It's clearly wrong to claim child abuse merely because of the presence of metaphyseal fractures. The good news on this is the RCPCH and the College of Radiologists are looking at the issues of non-accidental injury. However, we also need to look at the conflict of interest caused by the way in which payment is received for reports. If people only get paid for diagnosing child abuse, then we are going to get more child abuse diagnosed. The above two cases were ones which were almost certainly from well-motivated physicians. The case of the prosecution of Marianne Williams in Wiltshire, the salt poisoning case, was, however, a very different and more worrying case. It resulted in the person who was responsible for the care of her son and who would be an alternative suspect of the cause of the child's death driving the prosecution case. There are also cases such as that of Ben Hollisey McLean, where the threat of child protection proceedings was used to force him into dangerous medical research. I have evidence where child protection proceedings have been used to silence parents. Indeed, parents have been forced to admit that they harmed their children when they didn't, simply to keep their children. This invidious aspect of the system where parents are caught into the catch-22 word of social services is one of the most pernicious. This is also a reason why it is difficult to get clear understanding from the research. The misery caused by Roy Meadow, who followed in the tradition of Matthew Hopkins, and David Southall, who shared that ancestry and that of Joseph Mengele combined, is something they should have to account for. Even if their motivations were good, the consequences will hang over many people's lives for decades. The witch hunts where mothers are alleged to have killed their children and are then required to prove their innocence against unfounded medical opinion need to stop now. That does not require a change to the law, but it does require a change to procedure. Apart from where the system basically gets things factually wrong, there are issues when the system gets the facts right but takes the wrong action. I know of a woman in Birmingham with epilepsy whose children are continually taken off her at birth. I think she has now had 5. She has expressed the desire to continue to have babies until social services allow her to keep one because they run out of money. We really need to look at these cases and see why it is she cannot be supported to keep at least one child. We also need to look at how issues of domestic violence are handled. It's wrong for when a mother who's a victim of domestic violence finds that social services try to remove her children from her without trying alternative approaches. I'm aware of a case at the moment in Sunderland and a second in Devon where this is happening at the moment. The underlying issue, however, is a fear of missing a child at risk. This means that people tend to play safe and treat a normal situation as one where the child is at risk. Cases like Victoria Climbié are ones which abuse is obvious and should not haunt the system, driving people to treat normal situations as abusive. Common sense is needed to bring balance back into the situation. One key point about the Climbié inquiry is it showed that the social workers there were busy chasing up the chimera of a few MSBP cases and didn't actually have the time to focus on a very serious case of abuse which was ignored. We clearly need to separate out the child protection function from the supportive function of social services, much that obviously under Every Child Matters it's been reorganised slightly anyway.